Good afternoon, ladies and gentlemen. You are watching Public Comment Live. I'm here to discuss with you relevant news of the day or the week, trending issues, etc., specifically in relation to politics, though sometimes I digress. Well, I want to start by saying this. People can sometimes say things that demonstrate, unfortunately, that they just don't read. Suggests that not only do they not read, but they don't annotate what they read. They don't draw from what they read. They don't corroborate or seek corroboration with respect to what they read. And this is evident not just in some of the things that people within our own government say. This is evident even in things that people say on social media. So I want to talk to you about that first. The format today, the way that I'd like to go about this, I did this a few days ago, a week or two ago, actually. The forum here, the way I want to do this is just kind of talk about the stuff I'm reading. And there's a reason why I want to do this. You see, as I observe a number of conversations, for example, Facebook conversations that I have participated in or observed, one thing that I notice is that people talk fast. They talk very hastily and usually resort to personal attacks instead of intellectual discussion and debate through objectivity and examining the logic or lack of logic in a particular claim, a particular alleged deduction. So I want to share with you some of the weird things that people have said to me on Facebook that demonstrate that their opinions are uninformed. And I also want to talk about that concept of having an opinion and what is an opinion? What is the value of an opinion? What is the credibility of an opinion? Some people will say you have opinions and then you have facts. That is true, but I would like to add, there's also the fact, and this is a fact, you have factual opinions, that is, opinions or judgments or presentation of thoughts that are based on facts and logic, or you have opinions that have no facts, that are mere emotionalisms and disconnected, disjointed thoughts that just don't seem to suggest anything. So I'm going to share with you then some things people have said to me in an attempt not to disprove or refute what I say, but I don't know, I'm not sure what the objective is other than to insult me. And yeah, you know, I don't usually get bothered by when people insult me. I don't like when people insult other people, but when folks insult me, I just take it as evidence that they don't know what they're talking about. And so it saddens me that they are so lacking in intellectual confidence that they must resort to this. However, I wouldn't say it gets to me. So I don't know if your desire in throwing personal attacks at me is something that is going to make me change my mind. I don't know if you're hoping that I'm going to sit in the bathroom and cry, but that's not the effect that you're having if that's what you think it's having. Instead, what I'm doing is I'm just keeping track of all of them and noting the lack of objectivity, noting the lack of presentation of facts and making deductions based on those facts or making inferences based on those facts. So, okay. One of my Facebook followers, his name is Timothy Francis O'Brien. I don't know too much about him other than that he's a libertarian, member of the Libertarian Party, and that he dislikes me, and he likes to talk about how much he dislikes me. So let me give you some context. I'm reading from you some comments that were made in a video that I made when I was in Washington, D.C. I think this particular video, I was in front of the Capitol building. And what was I talking about? I was talking about the fact that it is true. The President of the United States can be indicted, ought to be indicted, perhaps will be indicted. And so my critics didn't like that I made these claims, and I want to share with you what they said in response to me. And I would just preface this by saying, no, they did not look at any of my arguments or look at anyone's arguments with respect to this and explain the contradictions. They just resorted to personal attacks. So this guy, libertarian Timothy Francis O'Brien, said to me, "You have TDS bad." Of course, TDS, as we now know, means Trump derangement syndrome, kind of a strange concept and a strange term that Republicans use to keep going an ad hominem attack on liberals. And it's funny that our political landscape today is so desperate, so lacking in intellectual substance that all they have are insults, but that's what it is. So that's Timothy Francis O'Brien's attempt to disprove what I say. So by saying that I have Trump derangement syndrome, does that in any way disprove that Trump can be indicted? No. Instead, he's focusing on me and who I am, or what his interpretation of me is. And he's not even talking about the legal discussion and the set of statutes and Supreme Court decisions that have been made. He's not referring to those. He's just making a personal attack. And it's just sad that there is such a lack of critical thinking in the political arena today. What else was said that I found just wild? Okay. Another thing that Timothy Francis O'Brien said, which was very interesting. He said this. Sorry, my paper is a little sloppy because I have a paper clip. Okay, so we're talking about the question as to whether the president can be indicted. And he says, there is no statute governing this. Remember, the president is the head of the legal branch of the executive branch. He cannot be ordered around by people who are supplicants. He cannot be deposed by the Justice Department. So Timothy Francis O'Brien is suggesting that there's no statute governing whether or not the president can be indicted. He's wrong, and I will share with you the statute. If you will give me just a second here. It's kind of ironic because he talks about impeachment, and he just doesn't seem to understand or have much knowledge about impeachment. So let me read to you the impeachment clause. If you read the impeachment clause, and the final part of it actually says that anyone who's impeached can still be subject to indictment, trial, judgment, and punishment according to law. That's in the impeachment clause, so he's wrong. But he can go on making his personal attacks. And so here's the point I'm trying to make by moving papers around too. That's why I like this style sometimes, as opposed to just writing. Sometimes it's easier to just touch the source and talk about the source. And that's the whole point, is when we're having discussions, especially really technical discussions, you have to say, why do you think what you think? What is the evidence? What proof do you have that backs up your claim? This is something they teach in high school. This is something they teach in college. It's just called critical thinking and substantiating an argument or a claim. So the point is to have a source, to be able to analyze it, to be able to look at it, to be able to think about it, and ask questions about it. and to note things that stand out. And that's why I like annotating, as you can see. I don't know if there's a glare there with the light, but I apologize about that. And by the way, there is much more that is said on this topic of the degree to which, in fact, the president can, for a lack of better terms, be ordered around by people within the executive branch or the judicial branch, or, as we know, the legislative branch. But I will get to that when I move on to another source. That's going to be a really interesting one, and I'm excited to talk to you about that. And what that is, I'll just give you a quick preview, but we'll get to it later. But what this is, and I'm really excited to talk to you about this, actually. I was doing research and just happened to come across it. So you might remember Kenneth Starr, the special prosecutor who was investigating President Clinton. So Kenneth Starr was curious as to the question, can the President of the United States be indicted? So he sought out legal counsel. And a well-regarded professor of law, the late, unfortunately, he just passed away this year, Ronald D. Rotunda, wrote Kenneth Starr this letter. And in this letter, he goes through, I think it's a 60-page or so letter. He goes back and looks at things that our founding fathers said about impeachment and indictment, things that Supreme Court justices have said, things that other legal scholars have said, all surrounding this question of, can the president be indicted? It's a good read, and I'll be talking to you about that very soon. Some other things this person said, Timothy Francis O'Brien. He said to me, your words indict your lack of discernment. And maybe he meant indicate, because I don't know that indicted would be used in that context, but that's getting probably close to pedantic. But I just don't know exactly what he meant by that. But what's interesting is he says your words indict your lack of discernment, but he doesn't show the lack of discernment. That is to say, if I'm going to say that you're wrong about something, it's one thing to make like a ad hominem attack on your character, which, by the way, doesn't prove or disprove anything. But the point is, when something is incorrect, what you need to present is a contradiction. So in other words, just making a blanket statement about somebody or what somebody said isn't an argument. It doesn't hold really powerful intellectual weight. And that's why I put in my subtitle today, I said that some people should learn to think more critically. Because it's true, critical thought, in the realm of critical thought, when we're making an argument, even if you're writing a basic college paper, what are you taught to do? You're taught to have a thesis. What must the thesis do? The thesis must answer a question. The thesis, therefore, must include proof and explanation. So instead of throwing out these personal attacks like, oh, your words indict your lack of discernment, how about saying instead, this would be much healthier, oh, Mr. O'Connor, you said the pen is red, but actually, as you see here, these are the colors, this is blue, this is the color that the pen is, that's blue, right? That's how you show a contradiction. But we didn't get the presentation of a contradiction from Timothy Francis O'Brien. We did not. In fact, here's what's ironic, and it's so interesting. If you actually study the people who throw personal attacks at you on social media, you'll usually find that they tend to contradict themselves quite plentifully. So here's a contradiction by Timothy Francis O'Brien. Okay, he talks about the role of Congress. Here's what he says. Congress is constitutionally barred from even writing such legislation. He's talking about legislation where it might lay down explicitly that the president can be indicted, even though it really already is. But here's what's interesting. So he says that they are constitutionally barred from doing this. But then he says, also, it would require the consent of the president, who could easily veto such legislation, rendering it moot. By the way, false what he said. But note what he's saying. He's saying Congress cannot pass legislation that would enable the president to be indicted, but they can if the president signs it. He's saying one thing and then saying something completely different. And he's the person who's saying that I lack discernment. Well, I beg to differ. I beg to differ. Here's the other interesting thing. He says that a law to be passed, right, would require the consent of the president. But he just must not know his basic constitutional law, because 2/3 majority overrides the president veto. That's basic political science 101. In fact, I think they teach that in like middle school US history, if I'm not mistaken. Maybe I am on that point. But it's just funny. We have these grown people, adults, who spout contradictions, personal attacks, and flat out incorrect information, and yet expect to be taken seriously. And that's what I can't really wrap my mind around. You see, reasonable people can disagree. It's one thing for us to have a conversation and have two different points of view. And what would that look like? That would look like me saying, okay, let me give you a presentation of facts and interpretation about the implications of these facts. And then person number two says, no, hold on a second. I know that you're saying this, but in fact, that's a contradiction. And I say, show me that contradiction, right? That's how a constructive conversation amongst intellectuals occurs. Yet the lack of intellectualism on our social media is, I should say it's astonishing, but I don't want to have such a dark view of society. But it is unsettling and it is unfortunate. And it proves that either people aren't taught the value of their own education in high school, or they just don't have good high school education. And that's too bad. So now here's a comment from Rob Tebow. I want to tell you about this Rob Tebow. And I'm going to be honest with you, I have a very complex relationship with this individual. Rob Tebow was the town councilman of Hightstown, New Jersey. Rob Tebow, to his credit, has in the past compiled a record of desiring political independence. He was a member of the Republican Party. He didn't get along with the Republicans, or he didn't agree with the Republicans, so he left the Republican Party. He was a member of the Democratic Party, but he couldn't see eye to eye with the Democrats, so he left Democrats, eventually running for mayor of Hightstown, New Jersey, as an independent. I've known former Councilman Rob Tebow for 5 years now. And he's a person with whom I've had many intellectual, political conversations. Yet it saddens me, or I should say, it disappoints me when he resorts to ad hominem attacks on the comments that I make. And I might expect that from disgruntled, uneducated individuals who just have a habit of not knowing what they talk about. But I can only interpret this as, I don't know. I don't know what exactly moves somebody to stray from an intellectual conversation and instead insult people. But this was a particularly interesting comment, which is why I want to share it with you. So again, we're talking about the topic that all of these comments that I'm reading to, they all stem from my claim that the president can in fact be indicted. And so here is what former town councilman Rob Tabot of Hamilton, New Jersey, former mayoral candidate, said to me. He said, "You are not an attorney. You have not attended law school. You are not part of the investigation into Donald Trump." Note the implication here, ladies and gentlemen. It's very important. What did Rob Tabot not talk about? My argument. What did he talk about? My credibility. Philosophy 101, where you learn about fallacies, would call that an ad hominem attack. It's a fallacy. In other words, it has nothing to do with the actual argument. It's a desperate attempt to push away the argument and hope that the distraction of insulting somebody will sweep away the minds of the vulnerable. Coming from a politician that I've had such high regard from, it was a disappointment to me when this occurred. But let's talk about this. Let's talk about this more deeply here, because it's important. We are all, and my wife and I had a nice discussion about this, because it's Rob Tabot, I'm always willing to, even when I disagree with him very passionately, I have an appreciation and a nostalgia, maybe it is, for some of the great conversations we've had. That is, I like to think that he will not go morally, ethically astray. But what does it mean when you tell someone you're not a lawyer, therefore anything you say about the law has no credibility? Think about the implications of that, right? As my wife and I were having this conversation, and she was bothered by this. Let's start at the very beginning. Let's look at this from the most broad perspective. And I'm going to give you two things to consider here. Number one, who votes for the President of the United States? And who votes for members of Congress? Who votes for the governor of the state? Who votes for freeholders or county representatives? Who votes for local members of the municipal council or city council and mayor? The people. The people vote. The people ultimately make a discernment in the realm of politics and in the realm of law too, in one context, right? There are two contexts when we talk about law. There is the realm of lawmaking, of which we take a part. In fact, not only by voting for representatives who will vote in favor of legislation we want, but, and you see this especially on a more local level, but we can call for referendums. We can have a petition signed and mandate that things get on the ballot locally, statewide, right? So the people absolutely have a say in what will be law, first of all. We have an absolute say. But we also, this notion that, well, I'm digressing. So I said there's two ways to think about involvement in law, right? There's lawmaking, as I said, of which we are a part, but then there's the judicial branch, right? This is where things get debated. Was this a violation of the law? And if so, how so? And you have lawyers who will debate this. And if a judgment of a jury is disputed, this goes to the Supreme Court. Well, first it goes up the board, it goes up to the appellate courts, but then if it continues to be appealed, it finds its way to the Supreme Court, where judges, or justices rather, make a determination. Was this constitutional, or was this unconstitutional? Two different ways of looking at law. Now, the notion that a lawyer has a monopoly on legal understanding or credible legal thought is absurd and wrong. And when people use that argument, it's no other than their desire to just not listen to you, because they are perhaps afraid that with all of their time spent getting, passing the bar, they resent the fact that you could do it too without going to law school, or the desire to practice law and therefore not going to law school. I don't know. But the notion that people can't have opinions, or shouldn't have opinions that count just because they didn't get this degree or that degree, is absurd. It's utterly absurd, and it's wrong. And let's think about this on a basic level. Just let's do some applications, concrete examples, and really think about this. First of all, let's talk about really, really basic laws. Let's say, for example, it's illegal to run a red light. If I saw someone run a red light, I could say I saw that person break the law. I may not be a lawyer, therefore I cannot play the role of prosecutor, but there's a huge difference between playing the role of prosecutor and having an opinion which the prosecutor may or may not share. And you being or not being the prosecutor, when it comes to the credibility of a judgment, those are two separate issues. And so this nonsense, this utter nonsense, that you must be a lawyer to have a credible opinion on matters of law, is false. Utterly false. And again, in Philosophy 101, they would tell you that this is an ad hominem attack. They would tell you that you are attacking someone's competence instead of actually examining the content of the commentary presented to you. And this is something I note that is very fascinating about my critics. They don't actually cite my commentary, ever. They don't cite my commentary. They make comments about me. Generic, unsubstantiated comments about their estimations of my intellectual capacity or lack thereof, but nothing about the content of what I actually say. It's actually a fascinating demonstration of incompetence in the world of social media and the weird things people say, I would guess out of anger or just pure ignorance. And the irony too here, when we want to substantiate an opinion and we're really passionate about the substantiation of that opinion, what do? We back it up with evidence, and we go at length. The more passionate we are, in fact, usually, we will go to greater length to strengthen our cases. So, for example, you've got some angry person throwing insults at me, while, frankly, here I am with 7 different legal documents and articles, etc., presenting my analysis on a Facebook live stream video, putting in a lot more effort than them to solidify an opinion. So, oh, the irony. But alas, it would turn out that this is just the nature of people who don't self-educate on matters of justice. And that's the next thing to talk about here. Justice and the role we play. You see, at the very least, each of us has a vote and a voice that influences the direction of policy and the implementation of justice, right? Even if you want to talk about what it looks like, if even how removed are we? Okay, well, you're going to vote for a president who you think will select, who will nominate for the Supreme Court, to the Supreme Court, a man or woman who reflects your jurisprudence. So in a democracy, contrary to what Rob Tabot says, that unless you are a lawyer, your legal opinions hold no weight, I mean, that's just utterly false. Because in fact, to the contrary, ladies and gentlemen, educate yourself with respect to the law. The more we know about the law and the more we know about jurisprudence and the history of jurisprudence and the evolution of jurisprudence and what our philosophy of law is based on a synthesis of what people have had to say about it, we will make better formed votes for our president. And by the way, our senators, because the senators also play a role in confirming a judge to the Supreme Court to become a justice. And this is very important. I was once asked, what's my angle as a political commentator? What's my focus? My focus really in a overly simplistic, not over, but in a really simplistic sense is this. I like to think about things from the voter's perspective, the informed voter's perspective, because nobody, theoretically, can hold more power in the United States than the informed voter, because the informed voter votes. And that vote determines not just who is like, not just who is going to serve as an elected representative, but also probably what policies will transpire. Our vote is so important. The more informed our vote is, the better it is for our country. So don't ever, 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 ever allow somebody to make you feel intimidated or illegitimate or incredible because you don't have a degree that they want you to have, or because you didn't go through the procedures they say you had to go through. Yes. Is it true that to be a doctor, you need, obviously, to get medical training? Is it true if you want to be a lawyer and practice law, you must get a law degree? Yes. But to be a practitioner is entirely different than being a thinker. Two different discussions. Two totally different discussions. I am not a lawyer, therefore I don't participate in the courtroom. I may have opinions about what would be correct or incorrect judgments that should be espoused in the courtroom. Yes, and I should. I have a right to, first of all. But secondly, if I care about being a good, well-informed voter and citizen, I will. So anyone who tells you, well, where's your degree in medicine? You shouldn't talk about medicine. Then you say, ma'am or sir, with all due respect, I've done my research and my homework, and I don't need you to tell me otherwise. It's called knowledge. And in fact, in this era of this information age, people have more access to information than ever before, so that we can grow more educated, broadly educated in the world around us. Another thought here. Think about Abraham Lincoln. Yes, perhaps the greatest president in US history, the man who freed the slaves and won the Civil War and forever changed this country. The man who kept us from becoming two separate countries, one which was utterly immoral. Where did Abraham Lincoln get his law degree from? Anyone in the audience want to answer that question? Because it's a good question. Oh, that's right. Abraham Lincoln taught himself law. Worth saying again. Abraham Lincoln taught himself law. Worth saying one more time. And Rob Tabot, I'm looking you right in the eyes. Mr. Former Councilman, Mr. Mayoral Candidate. Abraham Lincoln taught himself law. Abraham Lincoln did not need some condescending attack on character to determine whether or not he was going to be informed about the law. He just went ahead and learned, and in fact was quite a successful lawyer. You should check out that story another time. Next, this was also a comment from Timothy Francis O'Brien, who said, he said this to me: state a case for impeachment with supporting evidence. You can't, there is none. Here's what's wrong with that. First of all, I did numerous weeks ago, it's on my blog, publiccomment.blog, where I outlined the case for impeaching Trump for treason. So the case or the outline, the presentation of things to consider is there. Now, if you disagree with what I said, the logical thing to do, the intellectual thing to do, the thing the critical thinker would do, would be to cite what I said, analyze it, and identify contradictions. But alas, Timothy Francis O'Brien is apparently not interested in intellectual engagement, only what they now call these days trolling. Yes, the one who says that I suffer from Trump derangement syndrome. Think about, by the way, the implication of saying that someone has Trump derangement syndrome. It means you're suggesting they're deranged. It means you are therefore refusing to engage with them intellectually. It means, therefore, that you are just part of a collusion, an attempt at collusion with, not collusion is not the right word, perhaps I just wanted to subliminally put it in there. A joint effort, if you will, to engage in dogmatic ad hominem attacks and totally throw out the window any opportunity for an intellectual discussion. By the way, what kind of people do that? Fascists, authoritarians, dictators. Yes. So that's that. I'm finished talking about these Facebook people who just don't know anything that they're talking. Oh, there was one thing, and this is important. This was the most, I was actually shocked by this. I'm so sorry that it's taking me a second to find this page. Oh, yes. Michael Cohen, Trump's former lawyer. Here's what Timothy Francis O'Brien said to me about that. And the fact that he said it just shows how uninformed, how disconnected from the world around him that he is. He says, Cohen pled to a non-crime. I'm sorry, have you even read his plea deal? Have you read his testimony in court? Obviously not. And for you, Mr. Timothy Francis O'Brien, I've got a treat. I've got the transcripts and the plea deal to share with you. These are things that I read today. You're wondering what my approach is, the way that I most enjoy doing these talks. I like to read stuff, annotate them, and then talk to you about the things that I read. So I was just going through a thread. I was taking, in fact, a day to read things my critics say and try to analyze what my critics say and make sense of them, or make sense of the lack of sense in them. So if you want to see what it looks like, this is the testimony of William Cohen. Not William Cohen, Michael Cohen. Sorry about that. But also I have, too, with a corroborating document as well, right? This is the plea deal. The plea discussion. That it's official Department of Justice document. Again, this is in response to Timothy Francis O'Brien, who said, quote, Michael Cohen pled to a non-crime. That's what he said. This is what, in fact, the Department of Justice says first. Then we'll get to Michael Cohen himself. Counts 1 through 5 of the information charge, these are the counts against Michael Cohen, charge the defendant with evasion of personal income tax in violation of U.S. Code Section 7201. That's a crime. Counts 1 through 5 each carry a maximum term of imprisonment for 5 to 10 years. So Michael Cohen didn't only plead guilty to crimes, but guilty to crimes that come with hefty punishments. Count 6 of the information charges the defendant with making false statements to a financial institution in violation of U.S. Code Section 1014. He broke the law. That's the law cited, right? I don't know if Mr. Timothy Francis O'Brien went to college. Not making a judgment one way or the other, but I don't know what his education is. But I know that in college, you're required, if you study anything in the liberal arts, anything in the social sciences or humanities, usually writing a lot of papers, and one of the things that you're asked to do repetitively is cite your sources and work with citations. That is, in other words, for those of you who maybe didn't study these things, you have to refer to your evidence. You have to refer to your source of your evidence, and you have to show it, and you have to say something about it, say what it means, all right? So we're citing laws that Michael Cohen broke, that he said he broke, and we're citing the document from the Department of Justice publicly verifying and making this claim. Yes, as one of my beloved, wonderful audience members said, it's called a bibliography. Where's your bibliography, Mr. Timothy Francis O'Brien? I'd like to see your bibliography, sir. There were other crimes, cited crimes, that Michael Cohen violated. Consider count 8. What did he violate? He violated 52 U.S. Code sections 30116A1A, 30116A7, and 30109D1A, and 18 U.S. Code sections 2B. So The claim that he broke no law has been refuted by the public record and Michael Cohen himself. And you ask me, why do I bother, right? Why do I bother examining the nonsense from someone who obviously doesn't know what he's talking about? And I do so because I think it is important for each of us to substantiate our cases as thoroughly as possible. And I think that also it's important to engage with one another. So while I find Mr. O'Brien to be utterly lacking in any intellectual effort whatsoever to have a conversation, I'm giving him an opportunity to participate in discourse at a more advanced level than he should be used to, apparently. In doing so, I'm hoping to actually create a good vibe, a good intellectual environment, community. You see, when Facebook comments and Twitter comments descend to a level of hasty insults, and if we accept this and we remain complicit in this practice, then we are degrading our communication. We're degrading the substance of our communication. We're degrading the ethics of our communication and the purposefulness of our conversations and our communications. I want good discussion. I want to promote very healthy, objective, intellectual, logical, diplomatic, polite discussions. And also, yeah, I like to be as thorough as I can. You can check out Michael Cohen's actual testimony if you'd like. I'm just going to give you the gist of it because there's one other thing I want to talk to you about today that I think you'll find very interesting. And that is this. So at one point when Mr. Cohen is making his plea, this is the text of his plea, the judge asks him if he understands the things that he's being charged with. And the court has it ordered that lays out, makes sure indeed that he understands it. So here's the judge. Ms. Griswold, for the benefit of the court and the defendant, would you describe the essential elements of the crimes charged in this information? So the judge is confirming that Cohen is pleading guilty to crimes. And he's outlining the crimes. And let's, a quick reminder of what those crimes are. The existence of a substantial tax debt, the willfulness of non-payment, failure to report that tax debt. How about false statements to a bank? How about this interesting one? We're talking about the campaign finance violations. Count 7 of the list of charges. With respect to count 7, causing an unlawful corporate contribution. And it's stated that there are 5 elements to this. Corporation made a contribution or expenditure in excess of $25,000 in Trump's to the effort of Trump's campaign, right? Second, that the contribution or expenditure was made directly to or in coordination with a candidate or campaign for federal office. This cannot be stressed enough. And I know that Trump supporters hate to hear this, but the fact is that the judge is saying Michael Cohen, you violated campaign finance law at the direction of President Trump. Do you accept this? And he says, yes. This legal document, ladies and gentlemen, this confession will live forever in history as one of the most astonishing events in the history of US legal proceedings. Because Michael Cohen, under oath and under the direct examination of a judge, said, yes, the president told me to violate the law. And it's stated here. Now, I want to talk to you about something very interesting. This was the most fascinating and enjoyable event of my day. I'll introduce you to this document. I talked about it a little bit earlier just to tell you what's coming up. What is this document? I'll give you a really good look at it, does it? So you can really see it. Ronald D. Rotunda. Who is that? You can see here. He served as counsel to the Senate Watergate Committee. He was the clerk for a judge of the U.S. Court of Appeals. He was a lawyer. He taught at the University of Illinois. He taught at George Mason University, and also Chapman University. Why does he matter? What's the story behind him? Ladies and gentlemen, let us go back to the 1990s. Certain aspect of the 1990s may remind you of the Russia investigation. And what might that be? That was the investigation into Bill Clinton. We may recall that President Clinton was under investigation. That investigator, as you may remember, was Kenneth Starr. It started with suspicion that President Clinton was involved in illegal real estate practices and evolved into not only examining the president's sex life, but a lie under oath and obstruction of justice charges, etc. And so a lot went on during that, I want to say it was a 7-year investigation. By the way, keep that in mind, ladies and gentlemen. How often do you hear people like Giuliani say, no collusion, this investigation has been going on for a year now, a year and a half, and there's been no collusion found? The irony is that the investigation that ended up with President Clinton impeached took 7 years. And he was not impeached for the issues relating to what the investigation initially began investigating. He was impeached because after 7 years or so, he lied under oath about his sex life. Okay, so in the midst of this investigation, Kenneth Starr, of course, does not work in a vacuum or by himself in isolation. It's a lot of people working for him, and he wants to consider all the different angles and implications and ramifications of this investigation. And so President Clinton. One thing that Kenneth Starr was very interested in or curious about was the question as to whether President Clinton could in fact be indicted. So he sought the legal counsel of Ronald D. Rotunda, who sadly just passed away this year. May he rest in peace. Again, let's re-examine his resume and ask, does that add weight to his credibility? And I know I said earlier, just because you're a lawyer doesn't mean you are absolutely credible or incredible. But at least we can say this guy has a fine resume. He was counsel to the Senate Watergate Committee. So he's been involved in that realm of legal questions about how the president can or cannot be liable in a criminal court, as well as with respect to impeachment. Going back to President Nixon, right? So he was a counsel to the Senate during the Watergate Committee. He was a clerk for a judge of the U.S. Court of Appeals. For a while, he practiced law. He then taught at the University of Illinois, then George Mason University and Chapman University. He was a professor of law. So I underlined just a few things that I really wanted to share with you from this. Things that are just important to talk about. Concepts, too, if you will, to think about. For example, where does this authority in the first place to have a special investigation into the president, where does that come from? That comes from a law passed in the late 70s. And it was a law that there were additions made to it. And that law may be known as the independent counsel law. Who signed the independent counsel law? President William Jefferson Clinton signed it. And that's going to have an interesting implication that we're going to talk about briefly. But I want to give you an idea of the nature of this document, this letter. I'll read you a few passages. So again, this is Professor Rotunda saying this to Kenneth Starr with respect to whether or not President Clinton or any president could be indicted. In order to answer the question, it is important to understand the constitutional issue in context. The question is not, as an abstract matter, whether any sitting president is immune from the criminal laws of the state or federal governments as long as he is in office. Rather, the question is whether, given the enactment of the independent counsel law, under which the independent counsel operates, the office of the independent counsel operates, given the historical background that led to that law, and given the constitutionality of that law determined in the Supreme Court case Morrison v. Olson, it is constitutional for a grand jury to indict this president if the evidence demonstrates beyond a reasonable doubt that the president is part of an extensive and continuing conspiracy stretching over many years involving witness tampering, document destruction, perjury, subordination of years, of perjury, obstruction of justice, and illegal payoffs. All serious allegations that in no way relate to the president's official duties. And why is that important? So this is discussed by Rotunda, Mr. Rotunda. It's discussed by Rotunda throughout this. But this concept is very important. That is the concept of official duties. It's laid out as one of the key points in this document, that what the president does in the context of what he can legally do, his legal obligations, versus what he does that has nothing to do with what he's legally supposed to do, those are things he can be liable for, says Rotunda in this document. Now, You may or may not have heard that certain members of our government are have the privilege of what they call immunity. Not entirely true, but let's see what's the conversation to be had about that, which Rotunda discusses in this document. Our written Constitution has two specific sections that refer to what may be categorized as some type of immunity from the ordinary reach of the laws. He says, and he talks first about the privilege from arrest. And this means that when a member of Congress is in session, actively participating in session, he cannot be arrested. Okay. True, but as Rotunda lays out in this letter to Kenneth Starr, that does not, quote, does not apply to at all to criminal cases. So if you are using that argument to say that the president has immunity because Congress has it, first of all, it's only with respect to Congress. It is not written in the statute that it relates to the president, relates only to Congress. And secondly, again, does not apply at all to criminal cases, of which President Trump is, well, we've watched him violate a plethora of laws before our very eyes, in plain sight. So the other kind of immunity that members of Congress have is this. If they were going to be tried for committing a crime, the one thing that cannot be used in evidence is the actual vote that they made. Say if you were going to try them for bribery or something. Anything else in the world can be submitted as evidence, but the actual vote of a member of Congress cannot be used as evidence in a criminal proceeding against them. That is the only other kind of immunity they have. So it's important, as Rotunda argues and presents in this letter, that this notion that there's immunity to be had by the president because Congress has it is just a great misunderstanding of, in fact, what the law says about this. Really, members of Congress have like a very narrow and limited immunity, and none whatsoever from criminal liability. And now here's an interesting thing. One point Timothy Francis O'Brien did make, in my opinion, not in a sort of logically connected thought, but a point that he nonetheless brought up that I think is worth talking about is, okay, but you don't need to indict the president anyway, right? Because Congress can just impeach him, and the Constitution gives Congress the authority to do that. So you don't need to indict him. He can be impeached. Congress can do that. The problem with that is, first of all, as is stated in the impeachment clause, impeachment doesn't spare the president or anyone from an indictment. It's explicitly stated in the clause. But secondly, ultimately, the two have almost nothing to do with each other, except, according to Rotunda, one thing, and we'll get to that. Here he says, one can find various historical references that assume that impeachment would precede indictment. But these references, as Professor John Hart Eli concluded, did not argue that the Constitution required that order. That order we're talking about, okay, so you'd be impeached and then indicted. It doesn't say in any statute, constitutional, federal, or otherwise, that the president must be impeached first and then indicted. Just doesn't say it. Here's another great point made by Mr. Professor Rotenda. If the framers of our Constitution had wanted to create some constitutional privilege to shield the president or any other member of the executive branch from criminal indictment, or to prevent certain individuals from being indicted before they were impeached, they could have drafted such a privilege. They certainly know how to draft immunity language, for they drafted a very limited immunity for the federal legislature. In other words, this notion that Congress had it in their mind that the president should not be indicted, or that the president was privileged to have certain immunities temporarily, if the framers of the Constitution made the effort to spell it out for Congress, would have done so for the president. And it's a good point. I noticed an error I made in the pages that I put together. But I want to read to you the impeachment clause to reiterate this overall point. Okay. Judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable, subject to indictment, trial, judgment, and punishment according to the law. That is a constitutional statute. I will repeat it. The party convicted via impeachment, this is according to the Constitution, shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to the law. You couldn't have it more explicit. People who go out of their way to obfuscate are doing just that. And it's political, not legal, not objective. It's political. It's an attempt merely to cloud people's brains and confuse them and deter efforts towards indicting the president. And that's all it is. Another point that I wanted to make to you. Okay. Apologize, I do. There's a lot of pages here. There was one really particular point I wanted to make sure I made with you, because I'm not sure I'm going to finish all of this. I'll probably have to do a part 2. But it has to do with President Clinton here, is what I want to talk to you about. Okay, so remember I talked to you about this very important law. And this law is the law which in fact permits for there to be a special counsel at all. It's very important to discuss this, and it's very important to know the history here. There was a law passed in 1978. It was called the Legislative History of Ethics in Government Act of 1978. This law establishes the authority of a special investigator, a special prosecutor, to look into the president. In 1994, a very interesting thing happened with respect to this law. It was reauthorized by President William Jefferson Clinton. And the implications of that are very interesting. So you might want to do this. You might want to take notes and just write down these two laws because, again, they imply a lot. 1978, Legislative History of Ethics in Government Act of 1978. And in 1994, Independent Counsel Reauthorization Act of 1994. Why does this matter? Remember President Trump's claim that he can control, if he so chooses, the special prosecutor? Not true by any stretch of the imagination. There are people who have said he can fire the special prosecutor if he wants to. He really can't. Not when the special investigator is investigating him. I mean, that's an obstruction of justice, first of all, but read into, in particular, Clinton's reauthorization of this law and what Professor Rotenda had to say to Kenneth Starr about that. If President Clinton had the complete power to control prosecutions today, Judge Bork's analysis would be applicable. Judge Bork had said the president could fire the special prosecutor, theoretically. But President Clinton made sure that he does not have the complete power to control prosecution. President Clinton and Attorney General Reno lobbied for the Independent Counsel Act, and President Clinton signed it. This law places important limitations on the Attorney General's power to remove the independent counsel. The independent counsel can, in brief, only be removed for cause. President Clinton signed the law and decided to give up his complete power to control prosecution. Under the statute, the independent counsel can only be removed for cause. The Supreme Court upheld the constitutionality of limiting the removal power in Morrison v. Olson. By the way, we have a comment from President Clinton on this law that is worth noting, as Professor Rotenda provides in his letter to Kenneth Starr. Kind of ironic, all of this. This law, says President Clinton in respect to the Independent Counsel Act. This law, the Independent Counsel Act, ensures that no matter what party controls the Congress or the executive branch, an independent, nonpartisan process will be in place to guarantee the integrity of public officials and ensure that no one is above the law. One last thing. You may have heard, and I apologize for running a little longer than I wanted to today. I wanted to cut it at somewhere between 45 minutes and an hour, but I just had such a trove of information I needed to share with you today. I want to know if you have heard of the Office of Legal Counsel. Do you know who they are and what they do? The Office of Legal Counsel serves the Department of Justice. The Office of Legal Counsel provided an opinion which former mayor and Trump's new TV lawyer, Rudolph Giuliani, cites when he says that the president cannot be indicted. What legal weight does something from the Office of Legal Counsel hold? Anyone want to wager a guess? 0%. No weight whatsoever. It is advice. It is an opinion. That doesn't mean the opinion might be right or opinion might be wrong, but it is not law. It is not legally binding. It is not something that Robert Mueller has to follow. It's advice. It's what they think he ought to follow. There's a really good article that I read today. I suggest you read too, and this is from Slate, slate.com. Can the president be indicted? There is significant reason to doubt those saying no. Very good article. It's written by Danielle Bryan and Sarah Turberville, and it was published this June. So it's decently timely. It is right when the Helsinki treason fiasco occurred. So the point is that in arguing that President Trump cannot be indicted, Mayor Giuliani is saying, no, the Office of Legal Counsel says that he can't. But I guess that Giuliani has gone mad because they don't hold any legal weight. It's advice. Nothing the legal counsel, Office of Legal Counsel for the Department of Justice says is enforceable whatsoever. And as this article points out, a lot of times they're actually wrong. A lot of times they're wrong and they make corrections. So not only does the Office of Legal Counsel that serves the Department of Justice, not only does it not carry the weight of the law, but oftentimes they're incorrect. And again, I'm going to encourage you to read this article from Slate about that. And I'll put it out there so you can just look at the title and you can Google it if you so choose. But there's another point that is made in particular by the Office of Legal Counsel serving the Department of Justice. And they say that, oh my God, to indict the president would just overwhelm him and he wouldn't be able to actually function as president. Our government would shut down, is the argument. So Bill Clinton was asked about that when there were questions looming as to whether he might be indicted. And this is what Professor Rotenda writes about in his letter to Kenneth Starr, one of the things that he mentions. Is it true? Is it legally true that the president could be overwhelmed by time, right, and very time consuming if he's indicted, all the legal stuff that would have to go on, that it would, A, incapacitate him and serve as president, and number two, therefore just shut down the government? Here's what Bill Clinton had to say about it, as cited by Professor Rotenda. When he actually, no, not when he signed, sorry, wrong point. Okay. Here we go. One should also note that it is easy to make a claim that the executive branch will simply shut down, but that claim is difficult to accept. President Clinton, during the pendency of the Jones case, this is important, said repeatedly, emphasize the word repeatedly, President Clinton said repeatedly that the looming civil case was not affecting his duties as president. So you have the President of the United States, former President William Jefferson Clinton, on the record as saying, this legal stuff that I am being inundated with is not impeding in my duties as president. Therefore, the argument that somehow it would impede Trump's duties to carry forth the duties of the president, it's in contradiction. Clinton says that's not so when he was facing legal trouble. By the way, Trump spends a lot of time going away and playing golf. He could easily be spending that time instead being held accountable to the law. Moreover, as Rotenda also argues, there is something called the vice president who's there actually. God forbid the president can't do what he needs to do. And in fact, there's an amendment in the Constitution if the president is incapable of doing something. It's called the 25th Amendment. So what we have are people who are just lying to us to basically interfere with President Trump being brought to justice. And so I conclude by referencing one final article. It's a very good article. It's written by John Nichols, who you may or may not know writes for The Nation. This is his article this morning. Impeachment is the cure for our constitutional crisis. I'm going to put the impeachment word aside for just a second because there's a more important fundamental legal and political and philosophical, even moral principle at stake. And that's what this article is really about. President Donald Trump, his supporters, argue that essentially the president is above the law. That's a fact. It's an utter fact. To suggest that the president can just shut down a special investigation, can't do it, flouting the fact that you can, suggests that you think you're above the law. How about this? The president thinks he can pardon himself. The president therefore thinks there's nothing he can do that is illegal that he should be punished for. Please let that sink in, ladies and gentlemen. This article, Impeachment is the Cure for Our Constitutional Crisis, by John Nichols, published in The Nation this morning, talks about that. And there are things that just really hit you about that. And so what's at stake if the president is in fact above the law, or we allow him, despite our laws, to remain above the law? That's what it comes down to. And this article, Nichols argues that this is what the whole purpose of impeachment is. We either say, fine, we don't like Trump, maybe we'll vote him out, but we're not going to hold him legally accountable. Or we don't. And we impeach and indict and try in a court of law and remove from office. If we do not hold President Trump accountable, and this is what this article argues, if we do not decide that he is subject to the law, how far will he push that? If President Trump continues to break laws and nobody does anything about it, he will take that as a green light to proceed. How far will he go until it begins to disrupt more visceral aspects of our day-to-day experience? And mind you, the things that he's doing now. Mind you, the president ripped babies from their parents. He was okay with that. The only thing that stopped him from doing that was that the nation was infuriated and he realized he couldn't get away with it. Then he went and he looked for another possible law to violate. And he thought about handing over US citizens critical of him and Russian President, autocrat Vladimir Putin, and decided to just hand them over to Putin so they could be interrogated. Then President Trump saw that Congress was upset, and he pulled back. Note a third thing. President Trump revoked the security clearance of former CIA Director John Brennan because he called him a treasonist. That's a violation of his First Amendment right, and it's an abuse of power. President Trump is testing you, ladies and gentlemen. He's testing all of us. He wants to see what can he get away with, and he will push, and he will push, and he will push. President Trump doesn't care about ripping babies from their parents. Think about that. He's a sociopath. He's cruel, and he's your president. And Congress has not deterred him successfully from attacking people. What Trump is doing is he's looking for people you won't care about. He will violate their rights. You will feel detached from it. It doesn't affect you, but it affects them. And they're in the minority. They're the elite intelligence officers. They're the brown people on the border. They're the diplomats. They're people who are not you. You don't relate to. You don't feel a visceral connection to it somehow. And he gets away with it. Babies ripped from their parents have not yet been reunited. How would you feel if the person you loved was taken from you by force? I thought about that long and hard one night when I saw about all this on the news. I asked myself, my God, how would I feel if my wife was forcefully taken from me? I cried, frankly. And then I felt rage. And I had to put my emotions away and ask myself, what is the proper thing to do to address this utter attack on basic ethics, basic human rights? You know, the first word to come to my mind was impeachment. The point is this. You and I, if we are accused of breaking the law, we are arrested and we go to court. And if we're found guilty, we have to pay a fine, do community service, or go to jail. Even the vice president of the United States, when he violated the law, right? Nixon's vice president, Spiro Agnew, he was indicted and charged and removed from office. Why is it that the only person in the entire country who cannot be subject to the law is the president of the United States? And what is the meaning of the fact that the one person who cannot or is not being held accountable to the law and subject to the law is going further and further to attack our rights and destroy the livelihood of this country and erode our democracy? Why is it that Trump gets to break laws but you can't? How does that make you feel? How does that make you feel? What does that make you think? Are you truly willing to live in that kind of country? So there's two ends to this discussion, two bottom lines. Number one, as I demonstrated throughout most of this talk, legally, according to the Constitution and according to Supreme Court testimony, judgment, opinions, the president can be indicted. The president is not above the law. If you want two basic elements of the Constitution above all else to cement the validity of that fact, consider two things. First of all, the impeachment clause says that the president can be indicted. It says anyone who is impeached is also liable for criminal prosecution. The Constitution also has a 14th Amendment, which says we are all of us, equal under the law. That's what the 14th Amendment says. So People can obfuscate all they want. People can play word games all they want. But one of the most fundamental political principles in this country, which we pledge to, when we pledge of allegiance, what do we say? With liberty and justice for all. Justice for all. Equality under the law. Yes, President Trump can be indicted. Yes, President Trump should be indicted. And that's separate to impeachment. Separate to impeachment. The president should be impeached and indicted, and in any particular order. So I'm going to leave it at that for today, because I went over time by a half hour. I want to thank you so much for taking the time to listen to my 2 cents, my public comment on this issue and the day's news. Really quickly, just as a show of appreciation, I want to take any comments anybody has. And I'm going to start with David McDermott. By the way, if you're just tuning in now, if you have any thoughts or comments, I'm taking them now. In the meantime, I'll examine some that have already been made. David McDermott says lawyers are mandarins. I'd love to know what you meant about that, David. I don't know. It's a level of separation between you and contact with it. David says, higher up, more it costs. David says, correct, take the founding fathers. Yes, it's really important, and I didn't get the chance today to cite some of the things that the founding fathers said. I just stuck to the Constitution, which they partook in the foundation of. But if you read the Federalist Papers and you look at some of the things that people involved in the Constitutional Convention said, they had quite the opinion that the president was just as liable to legal prosecution as anybody. David McDermott says, the informed voter, okay, but we can educate the rest. Yes, right? Not every one of us has all the time in the world to concentrate on politics. All of us should take at least a little bit of time to be as informed as we can be. But then there are people, perhaps, who are passionate about politics and are passionate about the perspective of the informed voter, who undertakes, either as a job or a passion or a hobby, etc., the constant examination of what's going on, and from a legal perspective, from an ethical perspective, from a political perspective, and looks at what should we vote for? Who should we vote for? What should the political agenda be? Yes, the informed voter plays just as much a role in that as the politician or the judge or the prosecutor. David says, we see political commentators in the UK, but they are always party-oriented. I think you do a good job. David, you are generous in your comment, and I thank you. Compliments feel like the most wonderful thing in the world, don't they? And David, your feedback too, I find always constructive, so thank you. But I also agree with what you're saying, that oftentimes commentators really just stick to the party's talking points. And that's particularly relevant when we're talking about this whole Trumpgate, right? This whole Trump fiasco, because people should put country over party. Examine the facts, not the obfuscations. And so, okay, I will say then, ladies and gentlemen, thank you so very much. If you didn't get a chance today to say what you wanted to say, I want your feedback. I want to know what you think. I want you to point out where you think my contradictions are, or if you think I said something great, that's awesome. Please feel free to check out my blog, where you can also watch this video, but also you can see other articles and posts and things at publiccomment.blog. That's publiccomment.blog. There you can see such things as my presentation, my case for why Trump should be impeached for treason, and you can see my endorsement for Josh Welly for Congress in his fight for Congress against Representative Chris Smith in New Jersey, along with other things. And coming soon, a post featuring this video that will be addressing the equality under the law and that stuff, and pictures and videos from when I was in Washington, D.C., making my voice heard. And hope you will make your voice heard. Ladies and gentlemen, if you liked what you saw today, I ask you to please share this video, because you got to spread the message if you really agree with it. Thank you so much, ladies and gentlemen. Have a wonderful day. Thank you, and I will talk to you soon.